controls the budget? Is it the principal or where?
Honorable the Minister.
Thank you, Mr. Speaker. Thanks to the member from Easton. Mr. Speaker, I understand that there are specific line items that are dealt with directly by the principals, but there are other items that are dealt with from the Department of Educational Services. And while I'm on that, perhaps, Mr. Speaker, I might as well make the announcement premature or not. I do have a subcommittee of my Education Council that are looking at school governance, and that in particular is one of the areas that I have concerns and have given some green lights to some very innovative changes that I would wish to announce come next school year.
The member for East End.
Thank you, Mr. Speaker. Mr. Speaker, may I respectfully submit to my colleague, the Minister, that therein lies the problem, that the budget is not controlled by virtue of those who are on the ground that know the needs, and the requests are often, in my view, not adhered to or acquiesced to by those who are controlling the budget. The Leader of the Opposition spoke about auto mechanics in one of his supplementary questions. I wonder if the Minister can tell us, again under the resources, when that auto mechanics department at the Clifton Hunter will be properly resourced, because oil and the necessaries are short in supply. And a roof over the outside porch where they work at their vehicles.
Minister.
Thank you, Mr. Speaker. Mr. Speaker, we're not in possession with that answer, but due to the fact of the recent inspector report and the issues that were highlighted there, the ministry and the department have organized meetings with a particular school to see how those issues can be remedied and a way to move forward. So I'm cautiously optimistic that we'll have a satisfactory outcome.
Next question.
The Deputy Leader of the Opposition, the elected member for Newlands, to ask the Honourable Minister of Education, Youth, Sports, Agriculture and Lands, question number 30.
The member for Newlands, the Deputy Leader of the Opposition.
Thank you, Mr. Speaker. Mr. Speaker, I rise to ask question number 30 in my name to the Honourable Minister of Sports. Can the Honourable Minister give an update on the plans for the Bordentown boxing gym? Mr. Speaker, before the Minister answers, I just want to make it known that I am actually a member of a director of the Boxing Association. However, I'm asking this question entirely in my capacity as a representative, and not on behalf of the Boxing Association.
You are not asking on behalf of the committee, the association. The Minister of Education.
Thank you, Mr. Speaker. The answer: during the last administration, the government announced plans to construct a boxing gym in Bordentown. However, the project did not progress beyond the design stage. During 2018-2019 budget process, as a part of the government's prioritization for capital works, the works needed for the Cayman Islands to be able to host the Crifter Games 2019 were given a priority. A boxing gym in Outer District remains part of the government's vision for the expansion of sports, but it is not a top priority item at this moment.
The member for Newlands.
Mr. Speaker, one of the minister could state if it will be a priority for the next budget.
Honorable Minister, if you want to give that kind of undertaking.
Mr. Speaker, that's been more than cautiously anticipatory, but I can certainly give the undertaking that it will be put forward, and based on what the national priorities are, it will be given equal weight.
The Deputy Leader of the Opposition, the elected member for Newlands, to ask the Honourable Minister of Education, Youth, Sports, Agriculture and Lands, question number 31.
The member for Newlands, question number 31.
Thank you, Mr. Speaker. I wish to ask question number 31, standing my name, to the Honourable Minister of Education. Can the Honourable Minister state what progress has been made with assessing the need for a third primary school in the District of Bordentown, and what interim plans are being put in place to deal with any overcrowding or resourcing issues currently being experienced at the existing schools in the district?
The Honorable Minister of Education.
Thank you, Mr. Speaker. The answer: there is currently no investigation into assessing the need for a third primary school in the District of Bordentown. There are no overcrowding or resourcing issues currently being experienced at the existing schools in the district.
The member from Newlands.
Thank you.
Mr. Speaker, if I could have...
Sorry, can you... Honourable Minister?
I looked at the answer and I recognized it was no, and I approved. And so I wish to ask apologies on behalf of the Ministry for that answer. The correct answer, which I approve, is as follows. If you would beg my indulgence, I might save some supplementary. The Minister of Education is ever mindful of the issues of increasing class sizes in some of the schools. Mr. Speaker, we keep a close watch on the class sizes, including changes in population and forecasted numbers. Plans are made based on this information, and in the summer of 2017, 3 classrooms at the Bordentown Primary School were expanded to accommodate the increase in class sizes. The room used to provide special education services were also renovated to increase the capacity. There is Crown land adjacent to the Bordentown Primary School that would allow for further expansion in the future should the need arise.
Mr. Speaker, if we could have 2 seconds to get copies of the
Yes,
answer.
the copies are being distributed. Oh, I see. That's the one that was withdrawn.
That's the one that is political.
We'll take a couple of minutes to get the copies of that, so in case there are supplementaries.
Mr. Speaker.
You need to call on me, yeah? The member for Newlands.
Thank you, Mr. Speaker. So one follow-up question. Can the minister state whether or not these plans that that she referred to in her answer take into account the two rather large developments that are being constructed now in the Newlands and Savannah area?
Honourable Minister.
Mr. Speaker, I'm reliably informed that the response is in the affirmative.
Member for Newlands.
Thank you, Mr. Speaker. Can the minister state what sort of increase is expected at Savannah Primary School as a result of these developments?
Honourable Minister.
Thank you, Mr. Speaker. Mr. Speaker, the Minister would have to supply that information as the Chief Officer, acting Chief Officer, is currently not in possession of those statistics with her.
Honourable Member for Newlands.
One last question. Can the minister then say that the ministry is comfortable that the Savannah Primary School can now accommodate that expected increase without any need to expand the school or make changes at the school?
Honourable Minister.
Mr. Speaker, the short-term plan is that there will have to be some movement in the catchment areas to be able to accommodate any unforeseeable or unexpected increase in the school population.
Member for Newlands.
Mr. Speaker, I'm concerned because changing catchment may mean that residents in Savannah, Newlands, may be then having to take their kids to Bartontown Primary in the morning, which is going to exacerbate the traffic issues in the district. Can the minister give us some assurance that this will be kept in mind when they're making changes to the catchment? Because I really think that it could make the situation much worse.
Mr. Speaker, again, I'm reliably informed that consultation is carried out with the relevant stakeholders and that the majority of students in that catchment take the bus that's contracted.
The member for Bartontown West.
Thank you, Mr. Speaker. Through you, Mr. Speaker, to the Honourable Minister. Just want to put one number out there. As per the 27 ESO annual report statistic, at the end of 2017, we had 5,488 persons on island with permanent residence. It is my understanding that a vast majority of those PR holders, their kids would not be entitled to public schooling. But considering in terms of long term, where some of them will eventually become Caymanians and their kids or dependents be entitled to public schooling, can the minister at least give an undertaking to this House to take a look at that population to see exactly what the future needs may be, because that is a large number to consider when factoring dependents and other family members that currently not entitled to free education or public education, but in a few years probably will. Thank you.
Honourable Minister.
Mr. Speaker, thank you and thank to the Honourable Member. Mr. Speaker, as I indicated, there is a working draft master plan for education, and when we meet, those are some of the demographics that we look after and some of the statistics that we try to import and input into the development of the master plan. Obviously, some developments, because they're not all government developments, come and catch you off guard, but there is communication, cross-communication with planning department whenever it's in hand there, so that it's plugged into the master plan, that it's a live-in master plan as we work on it. And there is provision, like I said, in the short term, because Bordentown currently, as I understand, is under capacity, that we could do a variation temporarily of the shifting of the catchment until we can get the school. The Bordentown and New Bordentown School is on the radar. It's not in the immediate radar, because obviously we have to do the Georgetown High School first, which is $100+ million. So there we are.
Member for Georgetown Central.
Thank you, Mr. Speaker. Can the minister say what is the normal procedure if a parent lives in a different catchment area than where the child has been allocated to if they have no transport?
Member for Minister for Education.
Thank you, Mr. Speaker. Thanks to the honourable member. An application can be made to the Director of Educational Services for exceptional circumstances, and she has a discretionary power to not put them in the previously allocated catchment. If I understood the question is what would happen if they were put in a catchment area and they did not have transportation. So, Mr. Speaker, the rebuttable presumption would be that if they stayed in the catchment area, that they would have had transportation. That's my response.
A member for Georgetown Central.
Thank you, Mr. Speaker. Can the minister say if the Prospect Primary School has transportation to pick up children from the Georgetown Central constituency catchment area?
Honourable Minister of Education.
No, Mr. Speaker, not that I'm aware of.
Thank you, Mr. Speaker.
Central.
Can the ministers then say what should a parent do if they have no transport and their child has been put into the Prospect Primary School by the Education Department?
Honourable Minister of Education.
Mr. Speaker, that parent could make an application to the Director of Educational Services, setting out the exceptional circumstances, and it would be duly considered.
A member for Newlands.
Thank you, Mr. Speaker. Mr. Speaker, I wonder if the minister could state whether or not the ministry or the department are looking at possible private-public partnership with individuals who could develop a private school in the district of Bordentown.
Minister of Education.
Thank you, Mr. Speaker. No, Mr. Speaker, that has not been under any active consideration, but from a preferential perspective and from my understanding of the government, which I'm privileged and honored to serve, that we would much prefer, especially at the primary level, for it to be government, because education is a keystone of a developing country, and it's our intention to nation build to world-class education.
Statements by the honourable ministers and members of the cabinet.
None.
Personal explanations.
None.
Obituary and other ceremonial speeches.
None.
Raising a matter of privileges.
None.
Government business bills. Second readings. The Immigration Transition Bill 2018.
The Honourable the Minister, the Honourable Premier.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move a bill entitled "A Bill for a Law to Provide for the Establishment of the Department of the Workforce Opportunities and Residency, Cayman,
to repeal the Immigration Law 2015 revision and for incidental and connected purposes.
The bill has been duly moved. Does the Honourable Premier speak thereto?
Thank you, Mr. Speaker. Mr. Speaker, some time ago, on behalf of the government, I made clear our commitment to putting in place a new approach to migration management in which the interests of Caymanians come first, but which also ensures that the industries which form the pillars of our economy are able to continue to recruit and retain the highest caliber personnel they need to remain globally competitive. As I have noted many times before, Mr. Speaker, the challenge of finding the proper balance between these goals has plagued successive governments for decades. Immigration legislation has been amended a multitude of times over the years, and while the changes were very well intended in every instance, I believe, they have ultimately not succeeded. It is time for fundamental reform. So, Mr. Speaker, with effect from the 1st of January next year, the management of border protection and migration will be undertaken by two new entities, the Customs and Border Control Service, CBC, and the Workforce Opportunities and Residency Cayman Department, known by the acronym WORK. Each entity will operate on its own legislative framework. You will recall, Mr. Speaker, that in June of this year, this Honorable House passed the Immigration Amendment Law 2018. That law started the process of transition to the Workforce Opportunities and Residency Cayman Agency by transferring many of the powers previously vested in the Chief Immigration Officer under the Immigration Law to the Interim Director of Work. This new bill, the Immigration Transition Bill 2018, that I am introducing now marks the second phase of that transition. The bill, Mr. Speaker, establishes work as a statutory body and removes all references to the Chief Immigration Officer and immigration officers generally. The bill also prescribes the functions of work and the duties of its director and officers. These include providing labor market demand assessments to government and the private sector, training and developing Caymanians and others for the workforce, providing a job matching and placement service for Caymanians seeking jobs, and processing applications for work permits, the right to be Caymanian, permanent residents, and other categories of residents. I would like to focus for a moment, Mr. Speaker, on the responsibility that work will have in relation to preparing Caymanians for the needs of the workforce. The bill prescribes that it will be a duty of work to promote and facilitate employment and re-employment in the islands through services and facilities that help Caymanians and other prescribed categories of persons to find and keep jobs. It will also be a duty of work to collaborate with and support employers, relevant representatives of commerce or industry, and public sector agencies in the islands to identify and promote industry-specific skills, to enhance the employability of individuals, and to increase workforce productivity and improve the international competitiveness of commerce and industry. Also, Mr. Speaker, a duty to promote and facilitate productive employment and employee career development, to promote and facilitate the adoption of best practices in the management of human capital, and to advise and make recommendations to the government on policies, measures, and laws that relate to the functions of this new department called Work. Also, Mr. Speaker, to encourage, promote, and facilitate the development of the human resources industry in the islands, to undertake research into workforce-related matters, and to conduct analysis and dissemination of labor market information and trends to the public, and to represent the government internationally in respect of matters relating to workforce development and public employment services. I'm therefore confident, Mr. Speaker, that through the performance of these responsibilities, a closer relationship between government and employers will be established, which will serve to protect the interests of Caymanians in the labor force and ensure that government has a sound knowledge of the needs of our industries and small businesses. Mr. Speaker, with respect to the second core objective of ensuring that our industries are able to remain globally competitive, new streamlined business processes are being introduced, which will facilitate faster turnaround times on work permit applications, but without compromising the quality of decisions. I should say the quality of decision making. Applications for work permits and other immigration facilities will be made through an online platform rather than on paper, and the requirements for supporting documentation will be simplified. Instead of advertising vacancies in a local newspaper, employers will be required to post the vacancy on a national clearinghouse portal and comply with a process that will determine whether there is a Caymanian available who has the skills for that position. So, Mr. Speaker, if employers wish to continue to advertise their jobs in any local media, that is a matter for them. There is no restriction on that, but there will be an absolute requirement to post their position on the new government portal. That process will also provide critical data to work in relation to labor market needs and skill shortages. Mr. Speaker, the process changes that I have just mentioned are not referred to in the Immigration Transition Bill because the IT components upon which they will be based are still being procured. The new requirements will, however, be brought into effect by way of further legislative changes in the first quarter of next year. Mr. Speaker, the duty of this new department work, and before that the Immigration Department, to consult with specific entities such as the Cayman Music and Entertainment Association and the Cayman National Cultural Foundation is also being removed in support of that objective. Decision makers will, however, retain the discretion to consult with any external entity if their views are deemed relevant to the application and where those views can be obtained without undue delay to the processing of an application. Mr. Speaker, the Immigration Transition Bill also proposes a change regarding the eligibility for permanent residence. And I think this takes some explanation, Mr. Speaker. I think it also deals with concerns that I've heard from time to time expressed in this House about the sometimes what can be, I suppose, construed as arbitrariness of some of the time limits on being able to make applications. As I always say, the law of unintended consequences has never been repealed, and often you don't realize, no matter how much time and effort you put into it, the full impact of provisions until you actually see them in practice. When the term limit for persons on work permits was extended from 7 to 9 years in October 2013, a restriction was also imposed that required persons who wished to apply for permanent residence to do so before the end of their 9th year of residence. The rationale was that there should be a cutoff point that coincided with the expiry of a work permit holder's term limit. The amended legislation also gave persons who were already here for more than 9 years on the 25th of October 2013, or I should say as of the 25th of October 2013, a period of 90 days in which to apply. Despite repeated public announcements and internal government circulars at the time, many persons who had been here for more than 9 years did not seize the window of opportunity to apply and have since then been blocked from doing so. So the result is that we have quite a significant number of people who have been here for more than 9 years, who are employed with government, who are spouses of persons who are on work permits but whose term has not expired, who cannot, despite meeting all of the other criteria, apply for permanent residence because they didn't apply within that 90-day window which was provided. Mr. Speaker, in addition to those who simply missed the deadline, many of whom are government workers, others have been adversely affected because of a change in their personal circumstances. For example, pardon me, Mr. Speaker. For example, where a person divorces from their Caymanian or permanent resident spouse after they've lived here for more than 9 years, they would currently be unable to apply for permanent residence in their own right, and they can't be granted a work permit because their term limit has expired. Similarly, a government worker who missed the opportunity in 2013 to apply for permanent residence may be forced to leave the islands should their employment come to an end because they can't get a work permit because their term limit of 9 years would have expired. Mr. Speaker, while the reasons for introducing the 9-year limitation for work permit holders are understood, there is arguably no compelling justification for imposing the same limitation on persons who are not subject to those term limits. Indeed, it can be argued that there are risks in depriving persons who have lived here legally for upwards of 15 years, and there are some of those, in the case of those who missed the deadline in 2013, or potentially longer from being able to apply for permanent residence. We are also confident, Mr. Speaker, having done the analysis, that by removing the 9-year restriction, only a limited number of persons would benefit. Since work permit holders have to leave the islands at the end of their term limit, the only persons who would benefit who are not already permanent residents or Caymanians are those who have been able to remain legally resident beyond 9 years on some other basis. These categories are the following: government workers, which currently number 145, not including their spouses, spouses of government workers, spouses of Caymanians, former spouses of Caymanians whose residence and employment rights certificate has been continued due to being the parent of a Caymanian child under the age of 18, and spouses of work permit holders where the other spouse has an unexpired term limit, and spouses of persons who have applied for permanent residence, currently 224. Mr. Speaker, in concluding my introduction of the Immigration Transition Bill 2018, I wish to thank all those who have been involved in the extensive work that is being undertaken to create the workforce opportunities and residency Cayman Department. As I noted earlier, Mr. Speaker, a further round of changes to legislation will be needed in the early part of next year to complete the transition once the IT components and new business processes are fully operational. That opportunity will also be taken to clarify particular provisions and to fix a number of technical anomalies that have been identified. Unfortunately, Mr. Speaker, due to time constraints and the need for this bill to be tabled on the current sitting, it was not possible for all of this to be included in this bill. And, Mr. Speaker, for those who might wonder, well, why didn't you simply wait? Mr. Speaker, we have to continue to move this transition process forward. Lots of things are happening. It's a very dynamic process. We are separating functions that were previously all part of one regime, one statutory and regulatory regime and one department. And we have to move the component pieces forward, as I alluded to in this, and the next bill I will bring is the Customs and Border Control bill, which again is that new agency is assuming some of the functions which were previously within the immigration regime. So we can't just have bits and pieces hanging out there, so to speak. We have to move them forward together. And as I have indicated, as the other aspects of the exercise are completed, we will bring further amending legislation, and in the end, then we will hopefully produce one consolidated piece of legislation so that you don't have to look all over the place, 2 or 3 different places to find what provision governs what matter. Yeah. Thank you, Mr. Speaker.
Does any other member wish to speak? The Leader of the Opposition.
Thank you, Mr. Speaker. Mr. Speaker, I rise to generally offer my support to this bill, in particular the separation of the work permit from the border control issues of immigration, as I have long advocated for a human resource authority. However, I do have some concerns that we are complicating the management of human resources by bringing over Cayman status and permanent residency, those boards and those requirements. And I believe the time may have come where we need to also separate that into a separate and give the human resources real opportunity to deal with the human resources and labor component of the country. I also want to strongly advocate for updating of the labor legislation, because I also believe that that needs to be brought in line with some of the new provisions that will be provided in this bill. Mr. Speaker, there are quite a few small matters that I will probably question during the committee stage, because I'm not sure that I fully understand the rationale thereof or why there is need to not do it in a different way. But some of the things is, I believe there's come a time, and some of this I know may be regarded as a function of the new business licensing regime, but I also believe that in the professional categories of the workforce, there may be a time now to look at some kind of certificate of need with some adjustment with what is available locally and what is being planned through the education system and manpower development, so that we can look more accurately and better determine what manpower work permit needs should go to permits. Because with a regime that allows 9 years and beyond, once the job goes to a permit holder versus a Caymanian, history has proven that it's a very difficult thing to terminate a permit and replace it with a Caymanian. In fact, in the few cases where Caymanians do get employment, where work permits were held before, it's usually because the work permit holder has been promoted, as opposed to being terminated and leave the island. So I believe some kind of certificate of need, particularly in the professions. The one that comes to mind is something like dentistry, where the professionals themselves will be able to make representation as to whether we need any more people in that particular profession or not. The one that comes, like I said, that comes immediately to mind is the profession of dentistry. Right now, there is no Caymanian in the dentistry field here, but it is very heavily subscribed by non-Caymanians, or if they are Caymanians, they're people who got Caymanian status. One would hope, and I know of at least 2 or 3 Caymanians that are either studying dentistry now or are contemplating and intend to be dentists. And with the subscription and provision that already exists, it is going to be very difficult for them to move into the market and survive. So that's what I'm talking about when I talk about another one that comes to mind is probably hairdressers. Well, that's not what the Caymanians tell me. The Caymanians, or at least the Caymanians, want to have the business even if they don't do the hairdressing themselves, right? That's why I prefaced what I was saying by saying that some of it should be controlled, and the certificate of need should also reply to the business license criteria. Another area that concerns me in the legislation is the board appointments. There's nothing in the legislation that places any kind of prerequisites on who can be appointed as board members. And I fully believe and I fully support the fact that the cabinet should have the authority to appoint the 12 members. But I believe the time has come where we should not simply rely on politicians to produce names for boards. I believe a more equitable way is to advertise boards' positions, clearly identifying for the public what the competencies are expected, what the reward is, what the duties are, and how people go through an interview process. I'm not recommending that it should be taken, the chairman should be taken to the extent of the American criteria where they have to be approved here in the Legislative Assembly. I think that should all remain in the cabinet. No. PSC is overworked as it is. We have enough to do, trust me. But I believe that, and I'd also wonder if we need to put in here, Mr. Speaker, the requirement that the public authorities law and the procedures in there for boards should also be extended to things like the Permanent Residence and Status Board and the various work permit boards. Again, one of the original intentions of the business staffing plans was to assist with manpower planning and manpower development, in particular the area of scholarships. And whether for lack of resources within the government, it has not been followed up. And nobody seems to know today how much scholarships have been given, whether any business staffing plan has actually met the requirements of their committed scholarship provisions, and what happens if no Caymanian applies for the job for a scholarship. Does it just fall away, or should that money be donated to some education fund? I believe there are other methods afoot and commitments by government to set up education fund, and that might be a way of getting some funds, because I can tell fellow members of this Legislative Assembly that I have seen evidence, and I have been involved with members of my constituencies and members in the wider community where persons have tried to access these scholarships from some of these professional companies that they have signed up to give, and they are really discouraged, and the process can be very onerous and very difficult even if one persists. So I believe we need to ease that provision in the bill. And Mr. Speaker, while I am not sure that whether the public will have access to this portal that the works is developing, because I think it's very important that members of the public have access to that portal. And I also believe that, for instance, if I come home from college and I'm a qualified accountant, yes, and can you also see what, for instance, people in the business staffing plan, whether there will be be able to look at certain institutions, or will it just be a global thing? In other words, if I'm coming home as a qualified accountant, can I go on that portal and see when certain work permits for accountants are expiring? Because part of the problem that I encounter with many of my constituents is that they come home qualified, they go to these various financial institutions and try to apply for a job, and they're told there are no vacancies. And that is true, there are no vacancies, but a huge number of their employees are on work permits that will expire that year or soon thereafter. And if the Caymanian could somehow see when that is going to happen and see some of the competencies that are required for that particular job. I don't think salaries should be exposed. That's not what I'm interested in. But to give for instance, Mr. Speaker, if I go on the website and I see that employee in company X, an accountant, work permit is expiring in 3 or 4 months, and I can look at what competencies that employee has, i.e., he has a bachelor's degree in accounting, has the CPA, has 5, 10 years experience, and I can compare it to my own competencies. Mine would be, I have the accounting degree, I have the CPA, CA or ACCA professional qualification, but I don't have the 5 or 10 years experience. But maybe that person doesn't have Microsoft qualifications and competencies in Microsoft. I can go and get that, which will be during that period of time between now and when the work permit expires, so I can apply for that specific job at that specific time. Because that is what I believe many of our young Caymanians need in terms of access to information in order to better prepare themselves. Because unless you know what the competencies are of the person who currently occupies the job, there's no way I can get the 10 years experience in 3 months. But I can, in fact, get other academic consequences which can partly compensate for that. Because as my old professor told me at the University of Minnesota many, many moons ago, 10 years experience can be 10 years experience, or it can be 1 year experience 10 times. And that represents substantial difference in one's capacity based on one experience. So I believe it's these kind of things which we now have, as the Honorable Premier suggested, and that we will be able to use technology to provide this kind of information to better enable Caymanians to access the job market and not be just set aside because they don't speak Greek or because they don't have 10 years experience. And I believe that the people that we have involved in this organization and the civil servants are capable of designing these systems and making it suitable in those areas. During the committee stage on the bill, I'll probably ask quite a few more questions, but philosophically, I agree with the separation from immigration. As I said, I have some concerns of bringing Cayman status and PR along, because I believe that that is going to consume a lot of the resources in that department. I'm not suggesting that it would consume any less resources or being cheaper if you did it under a separate entity. But my concern is that we may find ourselves, the people in works may be pulled in certain directions to assist with permanent residents and Cayman status, when the Caymanians need them to pull more in line with the Caymanians getting the job and getting the promotions if we're going to effectively address underemployment of Caymanians as well as overemployment. So thank you, Mr. Speaker.
Does any other member wish to speak? The member for Newlands?
Thank you, Mr. Speaker. I am also rising to give my contribution to the debate on the bill before the House. Like the Leader of the Opposition, Mr. Speaker, I philosophically support what the government is doing. I understand this is a... I guess they're not used to hearing me complimenting the government. Mr. Speaker, I support the move. Technical difficulties. As I was saying, Mr. Speaker, I support the changes being made, and I understand this is a transition bill only, and that there's much more to come. But I don't think it'll be a surprise to anyone to hear me say that I support what is being done. Overall, I think from a very high level, I have always advocated for the separation of some of these responsibilities away from border control, and especially when it came to labor decisions. Mr. Speaker, I'm very pleased to see that the government is actually, or to hear from the Premier that the government is going to move forward with the creation of a central clearinghouse, and that the use of that clearinghouse is going to be made mandatory by employers. You may recall, Mr. Speaker, last term I brought a private member's motion asking for that change to be made. And not trying to take credit for it, that idea came out of my involvement as chairman of the NWDA task force that was created, and many discussions with the key stakeholders who were involved in that process. And I want to thank Minister Rivers for spearheading that effort last term in her capacity as Minister for Labour. But I'm glad to see that that is now coming. I've always maintained, Mr. Speaker, that excuse me, in order to make the right decisions, especially when it came to work permits, the Immigration Department always needed to have better access to employment, vacancy information, labor information. And there were many times, Mr. Speaker, that people would complain that the wrong decisions were being made, and I understood from very early on that that was primarily because of the lack of information to support those decisions. So this going forward, I want to congratulate the government on taking the bold step of doing this. I know that there was pushback from some businesses. They didn't want to be strong-armed into doing it. However, it is something that is necessary if we want to be serious about ensuring that Caymanians get every opportunity to get employment when that employment is available. So I definitely do support that, Mr. Speaker. Mr. Speaker, I also, in discussing this here today, would like to take the opportunity to highlight a few issues that I think also deserve some attention while the government is going through this transition process. There are clearly still issues in labor issues and immigration and permit issues that are being complained about by many of our constituents. There's one, Mr. Speaker, that has been lingering for a while, and it's a bit of a double-edged sword because there's a practice now for some businesses when they want to move a Caymanian out the door, that they will initiate what I consider sort of a forced resignation, where they will call the employee in, have them sign a resignation letter, and then have them sign a non-disclosure agreement, and then hand them a check. And quite often that check far exceeds the penalty for unfair dismissal, their severance, and so forth. So for a short-term gain, a Caymanian is then walked out the door after having resigned, not been fired, and signed a non-disclosure agreement. Now, when I say double-edged sword, Mr. Speaker, it's because in some circumstances you may argue that you're doing the Caymanian a favor by giving them an opportunity to resign rather than fire them. But, Mr. Speaker, if that was the case in every single situation, that would be fine. However, that system that has developed, that process, which I know some lawyers are now offering that as a service to employers, helping them basically walk Caymanians out the door, that is being abused. And I hate to use the word abuse, Mr. Speaker, because just the simple fact you're doing it is abuse. But it's becoming quite prevalent now. And I've seen many Caymanians who've gone down that road. I think that practice has to stop, Mr. Speaker. I know that you may say that it will hurt a handful of Caymanians because the only other option then is to fire them. However, in the face of what I see as abuse that is taking place, if an employer can't find good reason to fire you, and they come to you with this resignation and the payoff, then they really probably shouldn't be trying to fire you. There may have been something that happened along the way. But I think the practice is becoming so common now that it is hurting Caymanians now. Whereas we may have said before, well, it would have helped this one or that one. I think it's just become across the board now something that needs to stop. And I think in going through this process, it would be good for the government to look at that and think of ways to make sure that the legislation covers that. If it's a redundancy and it's legitimate, fine. If it's, something along of that nature. But if it's just simply, I don't want this person working here anymore, let's give them a check and get rid of them, that has to stop. I know many professionals who have experienced that, and it's not something that I think we should turn a blind eye to, Mr. Speaker. Mr. Speaker, there's another issue, well, not really issue, but suggestion that I want to make in terms of developing this portal and the database. And I think this is the prime opportunity for it. And I've heard the member from Central talk about this a bit. I hope I'm not stealing from his debate. But we do need to start to develop a standard sort of classification for jobs, a job description that can be used throughout the industry, where individuals who are applying for, say, an accounting job know exactly what the requirements are to fill that role, and it's a standard set of definitions or descriptions for that job, rather than what we see now where people put out ads, employers put out ads, and they often throw in these special requirements. Secretary who can speak Russian. You may have Russian clients. I'm not saying that, but quite often what we find is that when you dig deep enough, Mr. Speaker, the individual who's hired has that special skill and they had it from before and it really doesn't relate to the job. So I know that immigration is supposed to uncover that. We have people who are trained to detect that. But I think what would assist in that effort is having and you can't do it for every single job, but a defined definition for these standard jobs, these standard roles, Mr. Speaker. Mr. Speaker, I still have concerns with Section 64, where not really concerns with the section of the law, but concerns with the abuse of it, and as it relates to job hopping. I know the last time I raised this in this House, this legislature, Mr. Speaker, the Premier asked me to come back to him with evidence of job hopping if I was led down that road to where I believe that was so prevalent. I have submitted now 2 FOIs, and first occasion, Mr. Speaker, what was sent back to me was that they can't fulfill the request because of the using 1 year, for example, the amount of data that they would have to go through. They can't do it manually, and the immigration reporting system can't produce a report showing me how many people changed employer not for special circumstances. So unfortunately, we don't have any information to go by, and unfortunately, the department can't provide that. And not to point fingers at them, Mr. Speaker, they tried. They've been trying for months now to satisfy my request, and I just got an email back today, actually, saying that, no, sorry, we just can't produce that report. So I have no way of verifying. Government really has no way of verifying. However, what I can state is that it is enough of a problem that Caymanians who are working in HR positions are reporting it to me and saying, look, you need to look into this. I've had some conversations, Mr. Speaker, with people in immigration who say, well, we think you may be justified in being concerned about this. The fact that we can't report on it means we can't check on it. So it could be being abused. That's something that I'm hoping that the changes will bring a more robust reporting engine when we look to enhance and use the technology that's available to us, because that one is quite a bit of a concern for me. Mr. Speaker, I agree with the Leader of the Opposition, Honorable Leader of the Opposition, about separating PR and status. I think that there's a potential that we could end up in a situation where the work component of what's being created may get overwhelmed to some extent. I think it would be better to have PR and status off into another area. That's just a suggestion. We'll see later on how the government plans to deal with that, but I do support the leader in that respect. And I also had a note here to talk about business staffing plans and scholarships and training, Mr. Speaker, and I'll repeat a suggestion made some time ago, is that maybe we need to look at having that process managed under the Scholarship Secretariat through the Education Ministry. We do have a concern, Mr. Speaker, and I think all of us share the concern that especially young Caymanians who have been working for some time, who have young families and so on, with the rapid changes that are taking place in the workplace globally, they need to remain competitive. And this is one way that, you know, a past administration decided that we could help Caymanians to stay current, keep up to date in their training and education. And if we're not actively enforcing this requirement of the business staffing plans, Mr. Speaker, then we're letting opportunities slip by. So I'm hoping that later on we will hear that, you know, this has been dealt with and that we now can actually know how many of these opportunities are being taken up, how many are being offered, how Caymanians can access them. Because the last time it was raised in this House, we really had no way of quantifying it or even assessing how successful it's been, Mr. Speaker. Mr. Speaker, one final area that I want to, and I'm raising all these as suggestions and areas that the Honorable Premier may want to look at and include in his discussions. Job agencies, employment agencies. I think it's time for us to start to regulate these businesses. And I know, you know, regulation sounds like a bad word, Mr. Speaker. However, let's just face reality for a moment. Some of them are abusing the system. I am getting bombarded with complaints from not just my constituents, Caymanians, that they are trying to get employment through some of these agencies, and they are not being successful. Quite often, the complaint is that they send in their resume, they send in their application, and they hear nothing back. When they call to follow up, they're told, oh, we only contact individuals who we think would be successful candidates. However, a lot of these, and I've sat with a number of them in my office in Newlands, Mr. Speaker. And I have a career. I had a career in the private sector. I was a global director of a law firm. I hired many people. I interviewed countless people. I have experience in this area. And when I sit and go through, and these are professional Caymanians with qualifications and experience, when I sit and go through their resumes, I look at them and I wonder, how is it that you were not called? You were not contacted? And what is happening is that when a work permit application goes in, the immigration department is being told that no Caymanians applied. And then when the person follows up, they get an excuse. Oh, sorry, that vacancy is now filled, but we have something else you could look at. And then they string them along for a while. I think that somehow we need to find a way to tighten up in this area, Mr. Speaker, because it's being abused. And we have to face that fact. It is being abused. There are many professional Caymanians who have gone the route of trying to use agencies, including myself, in a previous life, and had very negative experiences. I'm not beating up on the agencies. I'm not anti-agencies. I just think that if you're going to perform services in this area, and you're going to pass yourself off as a company, an organization who wants to help Caymanians get employment, then do it by the book. Let's get away from this situation where we know you're playing a game, you know you're playing a game, and the only one losing is the Caymanian who should be working, who should be getting the opportunity. And I'm not talking about entitlement or anything else. I'm talking about Caymanians who've earned the right, who have the education, qualifications, and experience, and they're still being run around as if, you know, it's a joke. So we need to get tough in this area, Mr. Speaker. Mr. Speaker, those are the main points that I wanted to raise. Again, I support what the government is doing. I understand we're in transition. And I will continue to support the Premier's efforts in this area. As I said, it's no secret that a lot of these things I supported him in doing, and I pushed and advocated for. And I look forward to further changes. Thank you.
Does any other member wish to speak? Does any other member wish to speak? Does any other member, the member for East End?
Thank you, Mr. Speaker. Mr. Speaker, thank you. Mr. Speaker, I rise to make a contribution to the bill to establish the Department of Workforce Opportunity and to repeal the Immigration Law 2015. Mr. Speaker, it is virtually impossible to debate this bill without having to refer to the other bill that is coming up, since the border control bill, since we are repealing this bill, when voted upon, will repeal the entire immigration law. which covers much of what is also in the border control. Well, you can try as much as you want, but if we look at some of the provisions previously in the immigration law, we can't but wonder why some of those provisions, one, have not been carried over into this bill, and further tying them in to the border control. But there are two separate bills, and yeah, and yeah, Mr. Speaker, I will attempt to do that and to avoid the anticipation and the likes, which we are quite aware of. Mr. Speaker, I am, whilst there may be reason to have a good feeling about what most of us have campaigned on for many years, including your good self, on the matter of doing away with the immigration department from and tying in work with immigration, with human resources, so to speak. In my view, there is much that this government has not done to appease that in the eyes of the public by bringing this bill, this transition bill. It appears like we actually did it in a rush with the intention that later on we'll do some more. Now, Mr. Speaker, we must, especially with the border control, we must manage expectations of our people, and I will say that at that time, because these things go through a transition, and it takes years at times to get these things, all the nuts and the bolts in place, and all of the T's crossed and the I's dotted. But I thought this was a perfect opportunity for the government to address some of the areas that the people have been crying out for. Mr. Speaker, but indeed, in the instance of Caymanian status, by removing the provisions for residency where there is a time frame to do it, out of within this transition law, we are in effect making it that much easier to reach that ultimate goal, because it's 5 years after the residency that you may apply for Cayman status, permanent residency. But the provisions of removing the 9-year term limit that you must apply within 9 years leaves it wide open for anyone to apply for residency over that 8 years, nevertheless. And there is no provisions to say how long before or in a minimum period that you must apply within. In the old law, the immigration law, if you're here for 8 years and you must apply before the end of the 9th year. Now, we have left that wide open for all and sundry to apply whenever. Mr. Speaker, more and more in recent times, I am hearing Caymanians, and I don't mean those of us who have 6, 7 generations, can go back 6, 7 generations here, but many of those who became Caymanian by virtue of grant as well, talk of stopping Cayman status, other than by descent and marriage, as I said in this honorable house, and I think the leader of the opposition said so at some stage as well. I thought the government would have jumped at the opportunity to try and correct that now and try and make some provision. Unless, of course, the government intends doing it when the time comes for additional amendments. Now, Mr. Speaker, when a few years ago, Rich and Connolly did a comprehensive review of the immigration law and proffered their positions on it. We are yet to have access to that, and I am not calling for access to it because it is a document that government engage these people to do for their own purposes. But certainly, if some of these provisions are coming from that, at the very least, we need to know what other provisions that is going to be expected in the not too distant future. I'm not calling for that document to be made public. I never did. I defended the government and not making it available to the press. I did. But certainly, Mr. Speaker, we need to look at provisions in the immigration law. Now it will be under work, where the pool of Caymanians as we know them do not continue to get diluted. There is nothing wrong with people staying here, Mr. Speaker, but Caymanians are crying out for provisions to ensure status is not issued like it has been done hitherto. I don't know the position the government is taking, but certainly I believe that some provision must be made for those who come here and live amongst us, but not to the extent that they can become status holders. Mr. Speaker, many years ago, Warren Connolly said to me, to hasten slowly, and that Cayman is not for everyone. I believe that that is as true today as it was then. We must choose carefully who are allowed unabridged privileges in this country. I believe that that is the only way we are going to survive in this country.
Honorable member. Honorable Premier, we reached the hour 4:30.
Thank you, Mr. Speaker. Mr. Speaker, I move the suspension of Standing Order 10-2 in order that the business of the House may continue beyond the hour of interruption.
Question is that Standing Orders 10-2 be suspended in order for the business of the House to continue after the hour of 4:30. All in favor? Those against? The ayes have it. Honorable member from East End, continuing.
Thank you, Mr. Speaker. Mr. Speaker, when we some years ago, and I don't have the exact time, one of the things that I believe under your administration, the UDP administration, we did was to remove provisions to allow those who could prove they were Caymanians that they did not have to reside here for the 3 years that was then in the law in order to be recognized as Caymanians. Mr. Speaker, I see that provision creeping back in. This law allows the old law under section 29, I think, makes, or is it 22? Makes provision to be granted the right to be Caymanian. And I think the new law is section 36. Wherein no, that's residency. Mr. Speaker, I see where there's a provision now for a residency of 1 year in the Cayman Islands to be able to be granted status by entitlement. And entitlement in this new bill allows requires one to be here for 1 year. Mr. Speaker, I don't know why that provision was put in, but I certainly believe that that is outside of what others have been calling for. Mr. Speaker, in that same vein, the member from Bodden Town and I from Savannah, and I brought a motion some time ago about making it more equitable or more equitable for Caymanian spouses to be granted residency or status, residency in particular, than others who had residency and could get it within 1 year. Their spouse could get residency within 1 year. And there is no provisions in this law for that. And that has been since 2013, 14. At the very least, those provisions should have been put in this law. At the very least, those provisions should have been put in this law. And Mr. Speaker, I don't know if the government will come back and say that those are ones that will be going in to other laws, other amendments, when those other amendments come. I don't know. But certainly, Mr. Speaker, it just shows a trend that we are not addressing in this bill the areas that affects Caymanians. Mr. Speaker, in the entitlement by entitlement, which, Mr. Speaker, I should add, does not or is represented in the law, should have been removed, because we removed the 3-year period. Here was a perfect opportunity to remove that 1-year residency of 1 year to coincide with the removal for those who were claiming it under other provisions in the law that was removed some time ago. The meaning of entitlement in relation to the right to be Caymanian under Section 26 in this case means entitlement by a person by virtue of the Caymanian being in the determination of the director of work, A, the child of a Caymanian, B, under the age of 18 years and legal and ordinary resident in the islands for a period of not less than 1 year. This was a perfect opportunity to remove that, because I recall during my tenure here, when we discussed that, the provisions for the 3 years, that you had to be resident for 3 years by virtue of right. We talked about the many Caymanians who were overseas, and that was an opportunity to get them to come back. Now, a child means the biological or adopted child. So I wonder if the government is mindful to take out the 1 year residency required by entitlement. Mr. Speaker, I believe that in itself would send a message to Caymanians who are, we have many Caymanians who reside overseas, albeit they have to provide proof and the likes. But certainly, for them to come here and sit down here for 1 year or more, they have no job, they have nothing, to be able to get status under entitlement, it is asking too much. It is really asking too much. Mr. Speaker, I cannot see why it is necessary to have that provision in the law. And maybe when the Premier responds, he can Mr. Speaker, I quite well understand that the fact that someone who has not been here, never been here, is difficult for them to adjust to our way of life. But certainly, Mr. Speaker, can think of many Caymanians who are overseas, that are professionals who cannot give up their jobs for 1 year to come to Cayman, and who wants to identify with the origins of their forefathers, and we expect them to give up their jobs to come here and sit down for 1 year to satisfy that requirement in the law. I believe we need to embrace these people who we know their parents, their ancestors came from this country. I believe we should jump at the opportunity to embrace them, and eventually hope they will come and participate in this country's development. I strongly believe that. But I believe that the government needs, and I don't know if the government is planning on immigration reform, because this does not cut it for immigration reform. It is copy and paste, and a few provisions being changed in there that does not, in my view, meet all that is being called for by the people of this country. Mr. Speaker, I look at, and when I said, Mr. Speaker, that it's kind of difficult not to do these things, Section 14 of the law, the current 2015 revision, Section 14 of the law makes provision for appeal from decision of immigration officer. Appeals from decision of immigration officer. And some of the sections removed from that are not now represented in this law, in this bill, is subsection 1 says, any person aggrieved by or dissatisfied with any decision of an immigration officer may, within 7 days of communication decision to him, appeals therefrom to the pertinent board. And subsection 2 says the appeal to which subsection 1 refers is restricted to dissatisfaction with the decision of an immigration officer. A, to refuse permission to enter the island, which should be transferred over to the border control. But when we reach that, we will see that those words are not put in there. B was repealed, and C, to revoke permission to remain in the islands. These are specific words: refuse an application for the grant of a student visa or the extension thereof, or to attach conditions to such grant. That's number 1 that has been brought over here. Refuse or revoke a temporary work permit. Now, Mr. Speaker, the fact that the director in work will have absolute authority but can delegate some of these responsibilities. There is no provision in here for it. And there may be a good explanation for it. Certainly the Premier did not explain why those appeals are not there. And then when you go over to the border control, the appeals does not go up to the appeals board, it goes directly to the director. And that's the last of your appeals. I wonder, in the interest of natural justice, if that is fair. And there may be some plausible explanation for it. I haven't seen it. And it may be I overlooked it, but certainly the government would, or should. Now, if work is dealing with work permits, then you would think that it would be in this bill, because there are provisions to refuse a work permit, whether it's temporary or not. Mr. Speaker, I should point out here that some time ago, Mr. Speaker, we amended Section 59 of the current law to allow for recreational sport fishing. I think the member from West Bay Central, myself, and your good self, Mr. Speaker, were the ones, and the leader of the opposition, I believe, to some extent, made representation on behalf of the sports, recreational sports fishermen. Now, Mr. Speaker, the fact that we are repealing this provisions should be made in the border control, which we have copied and pasted this over into that. However, if memory serves me well, that provision has been amended since we changed that in this law. Now, how that became changed?
On a point of elucidation, if the member will give way.
Honorable Premier, members given way.
Mr. Speaker, just to advise the member through you, sir, that what he's debating now is actually in the Customs and Border Control bill, which is about to come.
Honorable member from Eastern.
Mr. Speaker, I appreciate the the Premier getting up on a point of elucidation. It's just that I am saying it is no longer on this law that we are now repealing the provisions as I know it. But we are repealing this. There's no more time to talk about this law once this bill has been passed. I understand that, and I understand all this transition, and I said that initially it's going to take years for us to get this right. And we have to manage the people's expectations. I believe that it's the right thing to do. It's just that there are provisions, or there were provisions in this law. The border control law does not repeal this law. This immigration law repeals this law, the immigration law. Well, Mr. Speaker, if that is not so, then someone needs to get up on a point of elucidation and tell me what the long title of this bill means. Because the long title refers to repeal of the Immigration Law 2015 revision. Mr. Speaker, I guess when the time comes to do the border, and I discuss that.
Mr. Speaker, I am with some trepidation accepting the offer to rise on another point of elucidation. Mr. Speaker, breaking all kinds of protocols here now, but the bill to come is entitled A Bill for a Law to Establish the Customs and Border Control Service to repeal the Customs Law 2017 revision. And this is the bit: to repeal Parts 6, 7, and 8 of the Immigration Law 2015 revision, and for incidental and connected purposes. I hope that helps.
Mr. Speaker. Thank you, Mr. Speaker. And I know the Premier knows that I can read. In no sections on this one for repeal. Every one is repealed here. So maybe we should have said, with the exception of 6 or what have you, which is on the border control. And Mr. Speaker, I'm not trying to be difficult. I appreciate the Premier trying to point it out, but I saw that too. Yeah, and I appreciate that. Because it's only do 6, 7, and 8, really. But the immigration one says all of it. Yeah. Yeah. Pardon me? You got to repeal it double once that second vote has been approved in here. Oh, there will be no question. No, okay, I understand. Well, I thank the Premier for saying that. I guess we shouldn't worry too much about repetition, and you know that. It bears emphasis. For the government it does, for us it doesn't. No, mine is not tedious, yours is. Yeah, yeah, and I thank the Premier for telling me I'm off. I'm right off mic. He never does that on mic. But that's all right. We all heard it. Mr. Speaker, one of the other things that I need to know, and again the Premier may want to address this, under Section 26, if the person loses the right to be Caymanian, the Director of Work may cancel the passport acknowledgement referred to in subsection 2. I wonder if immigration is now, passport office is now going to be under work. Because as I knew it before, passport was directly supervised by the Deputy Governor. So would it not be because the immigration, the Director of Immigration was it is Section 20, Chief Immigration Officer. Before was doing that. But if there is now going to be a separation, there is going to be, I believe work is going to be under the ministry, under the Premier's ministry, and passport will remain under wow. If that's under him too, the premier as well. But was immigration not responsible for the passport office? Never was. There was a point it was. Now I don't know what has transpired in recent times. But on what provision would the director of work be able to resend that passport? And currently, I don't know if there's a need to do something about that if there is a separation there now. I don't know. No? Yeah, but it does, Mr. Speaker. A person who believes that he possesses a right to be Caymanian under subsection 1 may apply in the prescribed form the Chief Immigration Officer for the formal acknowledgement of that right in his passport, and the Chief Immigration Officer shall, within 14 days, either provide acknowledgement or give written reason for his refusal to do so, which I've always said that was not intended for us that got passport. Where he, by application, a law person loses his right to be Caymanian, the Chief Immigration Officer may cancel, or the passport acknowledgement, yes. I was overlooking, yes, the other one. And I want to turn to that one about this acknowledgement as well, because we're putting it right into copy and paste right now back into work. Again, the same provisions about this acknowledgement. And there is nothing wrong with it, providing we understand that is for those who were granted Cayman status. Well, it cannot be that me with birth certificate, having born here, and a birth certificate that, well, two of my parents, which shows that my parents born here, one was 1923. Pardon me? But that's what the private sector is asking Caymanians to get. Yeah, but why does Caymanian have to get an acknowledgement letter? They don't. Oh, well, you need to say that to the public because. Yeah, but Mr. Speaker, what the Premier is saying, what the employers are asking for is another matter. But under this provision is what they're doing it. So why does Caymanian who were born here have to get an acknowledgement? This is something that is current. But, Mr. Speaker, I understand the legal requirements versus what employers want should be explained to them from a legal perspective and from a directive from this government that there is no need for Caymanians to require that legally, the legal acknowledgement that they're Caymanians, once they have a birth certificate. Now, Mr. Speaker, I've always argued that there is only one birth certificate ever issued for any human being on earth. You can only born one place. You can only get one birth certificate of origin. Yet, when Caymanians produce their birth certificate, they're told they need the legal acknowledgement that they're Caymanian. Something is wrong with that. Mr. Speaker, the member from Prospect is interjecting there, and I guess he doesn't understand how far that goes. Because once you have given, if the employer so wishes, I think it's fair that they can go down and ask for one of your parents' birth certificate to show that they were born Cayman. Okay? Or a certificate saying that they were granted Cayman status, entitlement, grant, right, whichever. So now, but that one is easy for you to get. You go and get your parents. Most of us have our parents' birth certificate at any time to prove that we're Caymanian. Most things government require in this country, you have to show one of your parents' birth certificate. So a private employer, once they have seen that, then there's no need to go with immigration and get an acknowledgement letter. But they're not accepting that either. They still have to prove you're Caymanian, despite the law saying if you're Caymanian from, you have been recognized as Caymanian with the different conditions. That's the provision that needs to be corrected. That's what needs to be corrected. Now, Mr. Speaker, there are those who, by virtue of grant or entitlement, with that certificate from Immigration Board, saying as of such and such a date, this person is entitled to be considered or called Caymanian in accordance with the law. That's all they need to present to their private employer. But my birth certificate is no good. Despite me, if needed, can produce one of my parents' birth certificate that proves they're Caymanian because they were born here. Therein lies the problem, and I believe that needs to be addressed. If the government is going to bring it later, fine. But this entitlement thing, this letter of acknowledgement needs to stop. If it does not stop, it's causing concerns among our people. And I understand the difference between the legal aspect of it and what they require. But that needs to stop. This requirement that you got to go get acknowledgement when you got a birth certificate, I'm not going to do it. You're saying it's convenient? Convenient to go with the immigration department and get a letter of acknowledgement? When you get it here, the justification, you're given for that now. And all we need look at, the chief immigration officer, Mr. Speaker, merely requires you to show him your birth certificate and him or her, your birth certificate and your parent birth certificate. Same thing. So all the government needs to do is do a policy statement, release. Now there are different permutations of this that we need to correct as well. And we need to acknowledge. But the key is a national ID, which we have been speaking about for a very long time in this country. And I thought those were the things that we would do now. Mr. Speaker, I really thought we would correct all those things now. But if the government is going to do them later on, then fine, let's hear it. Because the presentation by the Premier wasn't as lengthy or as detailed as we would like that is usually done when we're presenting bills in this honorable House. And I know his handlers, the people who work for him, are prepared all that, and he ain't got the time to sit down and deal with that. I understand that. Mr. Speaker, that one and the one for Caymanian spouses needs to come soon. Anywhere else in the world you go, you're acknowledged as a spouse immediately. Mind you, we have gone a long way to do the RERC, Residence and Employment Rights Certificate, but it needs to go further. You can't have someone come in here, live here for 8, 9 years, get residency, marry someone who has never been here, come to the country, and within a week go and get RERC, and 1 year later get passport. And Caymanian spouses have to wait 7 years. Something is radical wrong with that. But the only thing we ever think about is this thing called marriage by convenience. And that's what holds those up. Mr. Speaker, was it this government that had accepted that motion? But it's not represented in the law yet. It isn't. But it's not even in the law. It's not even in the little amendments. So it hasn't been assented to. Yeah. But it's not amongst our laws. I don't understand why. Mr. Speaker, I know this immigration thing, like the Premier has said, has been the source of nothing but contention, nothing but worries. That's why I mean, somehow in support of the two Caymanian individuals who are now taking these two branches of government over, because I know one of them at least, provisions got to be put in place, one way or the other. But when the time comes, I'll deal with that. But Mr. Speaker, the immigration it's not going to make it any easier. I just think that one of the things that the Premier talked about was that he did say it was time for reform, and I want to see that. I'm looking forward to staying up late at night to read those proposals. That we can correct this once and for all, in the best interest, like he said, of the people, so that they're not treated unfairly. I'm paraphrasing what he said. The other thing was, Mr. Speaker, this thing of if people want to advertise in the newspapers, that's up to them to advertise it. But there will be a legal requirement for them to put it on the government portal. Now, I wonder if we're going to require the response, whether it's copper or otherwise, to be able to go on to that portal as well, so that the government can see the people who applied. Because one of the biggest problems we have had for years in this immigration thing, i.e. work permit, is that they'll say no one applied, and there's no way of proving it. It would be nice if there's no requirement for it, then provision should be made that a copy can be placed on there against that application, those advertisements, and Caymanians should be encouraged to do it, because one of the problems is that Caymanians do not want to do it because they fear they will not get the job, and it lessens their chance of getting the job. When they write to the immigration and say, I have applied for job so-and-so, so-and-so, so-and-so. Now we need to encourage Caymanians to do that so that the work director can have a better understanding of whether or not Caymanians applied. Whether they qualify or not is another matter. But they can verify, trust but verify, the response from the employer who says that they didn't get an applications for the job, for that position. And I agree with the leader of the opposition and the deputy leader. That labor law needs to be changed. I made a motion here. I did a motion here. 2014, I don't know. To do severance, redundancy. If they cannot prove that it's properly done, then they would have to pay up to 3 years in salary. And nothing has been done about that. We need, and it was accepted. Those are the things. I know, Mr. Speaker, you can't legislate morality. I know that. You need to enforce legislation, laws. But absolutely, totally, the provisions must be placed there, because when you do not have the provisions, people abuse the system. And then when the Caymanians, they can afford to pay 2 weeks in accordance with the labor law. They can afford that. So they give you that as your parting gift. And then when you appeal that it's unfair dismissal, they say they already paid it. If they were facing the possibility of 3 years' salary, then they would understand that they're not going to just fork out 3 years' salary. And I'm not trying to say that they got to keep people on the job. I don't get into operations. If someone is not fulfilling their employee contractual agreement, then they should be fired. But we hear too many stories of arbitrarily removing people from the work, constructive dismissal. These are the areas that, despite what people say, we need to put the fines higher and prevent people from doing it. Like someone said earlier, the only person who loses in this is the Caymanian. Yet, they're entitled to be a part of this country. Yet, we bring in HR people who dismiss Caymanians, who doesn't have any respect for them. I've always said, no one can fire you. You fire yourself by not doing what you're contracted to do. Well, maybe I need to change that, that position. And I'm changing that fast, Mr. Speaker. That has been changed fast because it is a fact that there are HR people in this country and owners who manipulate the system based on some prejudice. I don't know what it is. And get rid of people. And this thing about retirement, they're using that left, right, and center about this 16, 65 thing. Age 16, 65. They're using that left, right, and center. And that's what some of the things, and I see where the provisions the bill makes provisions for the director in the responsibilities to work with employers. I hope that, or support employers to collaborate with and support employers, relevant representatives of commerce or industry and public sector agencies in Ireland to identify and promote the enhancement of the industry-specific skills, to enhance the employability of individuals, and to increase workforce productivity and improve the international competitiveness of commerce and industry. Mr. Speaker, yeah, but I ain't gonna be long. That's not the break now and come back. Please, sir. I'll be 5 minutes, and then you can. Mr. Speaker, that I hope works for us. I know NWDA did some work, made some efforts, but I am looking forward to the new director who will ensure we promote and enhance the employability of individuals. Now, we can go so much, and we cannot go any further, Mr. Speaker. Mr. Speaker, I believe you and I were talking to a resident recently at a shopping center about that. We can do so much, and you cannot do any more. Whether you're Caymanian, you're on work permit or not. The government has, we may place as much responsibility as we want on the backs of the government and its agencies or departments. But if people don't want to work, they don't want to work, you know. And there's nothing you can do about it. Now, the only concern we have to have with that is whether or not they go then commit criminality to be able to feed themselves. But people must take on responsibilities too. So this is not a feel-good thing for Caymanians to think that because there's a new director and a new arm of government dealing with this, that they're going to get a job, or we're going to force people to give them a job. They have to work. That's what you were hired to do. You know, you didn't go. It's more than a job. It's also work. And those who do not want to work, then they shouldn't go to work. They shouldn't apply for the job. You cannot expect to be on the job, do no work, and get paid. Mr. Speaker, whilst this may enhance Caymanians and their ability to get jobs, to get work, like the Premier said, and everyone will say, it does not guarantee them staying on the job. It does not guarantee them staying on the job. And you can't run back to work after they get you on the job and say they fired me because I only went to work 2 days out of the week and didn't go 3 days. Because that is a habit in this country. And then they'll tell you, well, I was on my personal phone, you're not supposed to be on it, but here was, does it. Well, you're the only person get caught. You're the only person get caught. You don't know whether the others got caught or not. Caymanians need to know that this is not about entitlement. This is about opportunities. Opportunities to give you a reasonable life as far as humanly possible that you can earn. Two things never hurt anyone. My father told me that when I was, from time I can remember, when he was operating his trucking service. Two things, when I would cry because I had to change those old big tires that were flat. He would always say, crying never, two things never kill anyone, crying and hard work. Now stop your crying and get the job done. I had to dry up my tears. Unlike some of these who went and land, and when their father gave one basket, bring out, they started bawling. Unlike some of my colleagues in these chambers that couldn't walk over those sharp rocks up in East End, I had to walk there, even though my legs were like elastic. Mr. Speaker, I hope that the government brings us new provisions to address some of these other issues that needs to be addressed. We really need to address those, and that's what will make Caymanian feel. Those are the feel-good ones for Caymanian, when they are identified as a people. And the other thing I need to stop is this walking the dog being a volunteer thing to get Cayman status. That needs to stop. Thank you, Mr. Speaker.
The House will suspend until 6:30.